From 27 March 2021, significant changes affecting employers who engage casual employees were introduced into the Fair Work Act. Whilst casual conversion provisions have been a mainstay in many modern awards for some time now, the new changes to the Act puts casual conversion obligations front and centre for all employers and their casual employees. Do you know how these casual conversion provisions will affect your business? I'm Chris Campbell from Aitken Legal. For non-small business employers, casual employees who have worked for their employer for 12 months and who, during at least the last 6 months of that period, have worked a regular pattern of hours on an ongoing basis which, without significant adjustment, they could continue to work as a permanent employee, need to be offered the option to convert to permanent employment. This applies unless the employer has reasonable grounds, within the meaning of the Act, not to make the offer. Casual employees who meet this criteria also have a residual right to request to convert to permanent employment. And the employer can only refuse such a request on reasonable grounds. A small business employer is not required to proactively offer eligible casual employees permanent employment. But like non-small business employers, an eligible casual employee can request to convert their casual employment to permanent employment at any time after they have been engaged for a period of 12 months. Again, a small business employer may refuse the request on reasonable business grounds. Employers who engage casual employees should ensure that they understand the timeframes and obligations that are involved in offering permanent employment or responding to a request for conversion to permanent employment. There are numerous requirements that need to be met depending upon whether an offer is being made or a request has been made. So make sure you get advice that is relevant to your circumstances. It is also important to note that before 27 September 2021, employers who are not small business employers need to assess whether any of their existing casual employees are eligible to be offered conversion to permanent employment. These new provisions are not straightforward, so please talk to an experienced employment lawyer at Aitken Legal about your obligations today.